You're listening to Cover Your Assets, a podcast that discusses the timely and significant legal issues faced by employers. Kathleen Jennings is an attorney who has over 30 years of experience in advising employers as to their legal responsibilities and has written extensively about employment law in her popular Cover Your Assets blog. If your business has employees, you cannot afford not to have your assets covered.
Hello, everyone, and welcome to the Cover Your Assets podcast, your labor and employment law podcast. I believe, I did a search the other day, Kathleen, and I don't see any other labor and employment law podcasts out there that are nearly as good as ours. Can we start calling it the premier labor and employment law podcast?
I think we should. I think that our podcast should set the gold standard for all labor and employment law podcasts.
And indeed it has. And of course, last week we had a very special guest, my son, your nephew, Thom Jennings. We want to say thank you and for him being on, and we'll let him know how much we appreciate it. And we'll probably have some guests in the near future, but we're back to the old brother-sister routine again this week. And just a quick introduction, my sister Kathleen Jennings is our resident expert and labor law attorney. She is located in the state of Georgia, and I am located in the only state in the United States that ends with the letter K, if that ever comes up on Jeopardy, New York. So today, our topic is, again, a timely one that's been in the news of late, especially when it comes to labor and employment law. That is, it's mental health, isn't it? Like Quiet Riot, like people that need heavy metal at work. Was that the topic we agreed on?
No, Tom. Mental health is probably something you would tackle in your other podcast, in your other life. We're going to talk about mental health.
Mental health. It's amazing how one little letter can make that much of a difference. But yes, we are talking about mental health in the workplace. Again, very timely in a semi-post-pandemic world, but it's something that's always been kicking around. But this, and Kathleen, maybe you can introduce the topic a little bit as it relates to, I believe, maybe two laws or regulations, the ADA, and what else would it relate to?
Tom, I would say the ADA and the FMLA. And I would preface the discussion of this topic by saying that really employers should look at two aspects of this topic. First, how can they have a workplace that encourages people to have good mental health, or at least allow them to take care of issues involving mental health? And then we also have to be aware of the laws that prohibit employers from discriminating against people who have a disability that could be a mental health disability, cannot harass people on the basis of a mental health disability. You may need to give reasonable accommodations to people with a mental health disability, and you may need to grant them time off under the Family and Medical Leave Act, or FMLA, if your company is covered by that law.
All right, so let's start with some basics. When we talk about a mental health condition, it can be permanent, it can be temporary, correct? So,
correct.
In terms of the ADA, when it comes to mental health issues and reasonable accommodation, what are the types of things that maybe employers should consider when it comes to, I don't know, we'll throw out one that I feel is fairly common. Let's say anxiety and or depression. What kind of reasonable accommodations can an employer give that's not going to interfere with the day-to-day functions in the workplace?
That's a hard question to answer as a general proposition. Like a lot of these issues involving a disability, and in particular with a mental health disability, you have to take it on a case-by-case basis. So it becomes a conversation between the employee, the employer, and really the employee's mental health care provider as well may be part of that conversation. It would really start with an employee asking for some kind of accommodation due to their mental health condition. they may not use the magic words reasonable accommodation, but if an employee comes forward and says, I have this condition and I would like, for example, I need to work from home because I have anxiety, and working from home seems to alleviate the anxiety. I work better, I'm more productive, and would you do this for me? So that's a conversation where the employer would then look at, well, is this a job that can be performed from home? And what we've learned from the pandemic is that there are a lot of jobs that can be performed from home, probably more jobs than we ever thought could be performed from home. So although there may be some initial pushback from some supervisors or managers, because there's some folks that just like to see their employees, you have to look at the track record for that job and see, is this a reasonable accommodation for this person?
And this is an issue that has come up because of the pandemic, and I think you sort of touched on the fact that it becomes tricky because now there were jobs that required employees to come into the office, and really maybe jobs that the employer never in a million years would have thought could be done remotely, but then because of circumstances, they set up situations so that it can be accomplished remotely. But like I said, so I guess. So now we're coming out of the pandemic for all intents and purposes. So how does an employer make the argument that the employee that has, let's say, this anxiety disorder needs to come back in the office if they've successfully accomplished their job from home for, it could be upwards of 2 years?
It would be a hard argument for the employer to make if the employee has been able to successfully perform the job from home. And so that's the kind of history that you would look at to determine, is this a reasonable accommodation? Just wanting to see an employee in the office is probably not a good reason to decline that kind of request for an accommodation. So look at the background of the job, look at the employee. It's an individualized assessment in every case.
So I guess a question I would ask, too, is that as an employer is facing these situations, a couple things come to mind. One would be the potential for abuse. So let's say you have a workplace of 25 people. And we know we live in a society where everybody kind of keeps score. They worry about fairness. It's not fair that Kathleen gets to work at home, but Thom doesn't, and all those types of things. What can an employer do to prevent this? I guess we'll call it a domino effect, where you're the first one that says that you can successfully work at home, and then maybe, it says to another employee, hey, this is all I had to do is just get my doctor to say that I have anxiety, and now I can work from home. And so I guess that leads to, again, how does an employer potentially prevent that if it's something that they don't want? Because who knows, it may work out well for the employer to just have the employees stay working at home. We've seen employers that have benefited from that in terms of rent for office space and things like that. But I'm wondering what kind of documentation an employer can require from an employee that states that, yes, this is something that they need to be able to perform their particular job.
If an employee comes forward and says, I have an anxiety disorder and I would like to work from home in order to alleviate it, the employer can request documentation from that employee's medical care provider that shows that, in fact, this employee has been diagnosed with this condition, and even follow up with the provider and ask if working from home is indeed a way of alleviating the anxiety. Also, keep in mind that this information needs to be kept confidential. So it's a fine line here, because you have an employee working from home. And if you have another employee that says, well, Thom gets to work from home, why don't I get to work from home? The employer can't say to the complaining employee, well, Thom has anxiety disorder and you don't, so that's why he gets to work from home. The employer needs to keep that information confidential about Thom's condition. So the employer has to be very careful in how they explain why Tom's working from home and Kathleen is not.
And another piece to that. So once you have an employee that's working at home, somebody with an anxiety disorder, some of these mental health disorders can, like any illness, be temporary. So how often are you able to maybe monitor that situation? So let's say the anxiety is brought on by, post-pandemic anxiety, which is a very real thing, and many HR blogs and resources are writing about that has been the basis to say that the pandemic caused a certain degree of anxiety, some post-traumatic stress, all those types of things. How often should an employer check in to make sure that reasonable accommodation should be in place, because the disorder is still something that creates the need for that reasonable accommodation?
That's a tricky question, Tom, because you don't want to be constantly checking in with the employee and asking, hey, are you still anxious or are you doing better? So it may be where you set up a schedule of we'll check back in every 6 months, or maybe we'll check back in every year just to see how things are going, not necessarily to find out whether you still have the issue, but just to check in and see, is this working for you, and that kind of issue.
And, the documentation, I know a lot of times a psychiatric disorder, sometimes even like a family practitioner will provide documentation to that effect that they have a mental health disorder. Can you as an employer say that I would need more documentation to support this mental health condition? Or is it, again, fall into that category where if they provide the documentation, then you have to accept it as fact and provide those reasonable accommodations if it makes sense and when it comes to their job duties?
It would really depend, again, on the situation. If someone presented a note from their primary care doctor that diagnosed them with depression, and as a result of that, this person maybe needs to take a couple extra breaks during the day in order to meditate or something like that, you would consider that documentation, and you wouldn't need to ask that person, well, I need something from someone who's a psychologist or a psychiatrist. In some cases, there are some more severe mental health issues that you're probably going to get documentation from a specialist, because it's the kind of condition that requires specialized care. But you can't require that additional documentation unless you need it as part of the reasonable accommodation process.
And I know you work with hospitals, and I think that this is again another timely topic. A lot of healthcare frontline workers have dealt with, really significantly increased stress in their jobs. So what's the difference between, let's say, a mental health condition that is due to either, the genetic makeup, could be due to circumstances outside of the workplace, and a mental health condition that is a direct result of a person's job? So again, maybe a nurse or somebody in a nursing home would probably be a place that was pretty stressful throughout the pandemic. What is the difference when it comes to those types of situations, and where do they fall in terms of FMLA and ADA and all those types of things?
I don't think the genesis of the condition makes a difference. If the employee is diagnosed with a condition and they either ask for an accommodation or they ask for time off under the FMLA, then you need to consider the documentation of the condition and go through the interactive process to determine if the accommodation sought is reasonable. So it doesn't matter if it's something that is genetic or something that has been brought on by work or perhaps brought on by some life event. If they're diagnosed with a mental health condition, then you need to deal with it as the condition and not the cause.
So, a little bit back to the cause. So, maybe I didn't frame the question properly, but couldn't there be a situation where if a mental health condition is brought on and is proved to be brought on in the workplace, could that potentially fall under a workman's comp or a employer disability claim?
That would depend on state law. State workers' compensation law. In some states, mental health injuries are covered by workers' comp. In other states, they're not. I think this may also speak to one of the sides of the issue that I brought up at the beginning of the podcast, which is what employers can do to promote positive mental health in the workplace. What can they do to make the workplace a place where people will be happy to come to work? Or if they have mental health issues, how would you encourage people to go out and get treatment for them? Mental health is still something that has a lot of stigma, and a lot of people don't want to talk about it. And there are now companies that are trying to bring that out into the open by offering specific mental health benefits or encouraging people to really seek the help that they need for these and not keep it a secret, because untreated mental health issues have a poor effect on the workplace. It affects productivity. It affects the other workers around. You're going to have people with more absences with untreated mental health issues. And unfortunately, a higher rate of suicide among those folks as well. So it is in an employer's interest to try to encourage employees to do what they can to protect their own mental health.
Yeah, and I'm glad you circled back to that topic, because I think it's a very important topic in the sense that you want to create a atmosphere or workplace where people feel mentally safe. And I think employers, if they're going to be doing regular trainings for their employees, that these are topics that should be brought up. And I know working in special education and different and for different not-for-profits, that's always been a topic that comes up in a training periodically. Just saying, what do you do if you're dealing with a stressful workplace situation and everything? And I think we hear that term that's batted around a lot, the hostile work environment. So as an employer, I would imagine that you have to be very careful that when those situations are brought to the employer's attention, that they should take them seriously and certainly address them. Because, am I correct in saying that if a workplace environment becomes hostile and maybe it's not related to any form of discrimination, that there still would be potential for a lawsuit based on the mental health of the individual who feels that the environment is hostile?
Characterizing a workplace as a hostile work environment is really a legal term that's related to harassment in the workplace. What I would say is that, do you have a toxic workplace? Do you have managers or supervisors that are creating a toxic atmosphere? Some companies will regularly check in with employees to find out how they feel like they're being treated by their supervisors. Are these supervisors encouraging them, or are these supervisors acting in a way that's demeaning or bullying or things like that? Because that's the kind of toxic workplace that may not rise to the level of some sort of actionable lawsuit, but it's not going to enhance productivity in the workplace. It's probably going to increase the turnover of your employees. And you don't want people coming to work every day feeling miserable.
Yeah, very true. And one other thing I want to bring up and get your thoughts on. I don't know that there's necessarily legal ramifications, but especially if we're talking about mental health, and I'll base this on personal experience for myself and coworkers, is that it seems like a lot of employers have moved away from having a bereavement policy. And I think one of the most traumatic events that you're going to deal with as a person is when somebody very close to you passes away. And the pressure that could potentially be put on an employee who is not able to take off a suitable amount of time to, it may not even be the grieving process. It may just be having to deal with the administrative aspect of the death of a loved one. So what is your advice in terms of a bereavement policy? And again, have you seen any situations where, again, a mental health issue could be temporary? Like I said, I actually worked with somebody who wound up taking 6 months off on FMLA to just deal with the death of her father, because not only did it create the mental health issue, but she just had so much stuff that she had to deal with in terms of, cleaning his house out and everything, because they didn't live in the same area anymore. So what's your thoughts on that? Bereavement policy, deaths in the family, and how to deal with that in the workplace? And I'll let you talk after I say this one last point. I think it does send a message to the other employees that if somebody passes away, and I know you know this story, but like when our mother passed away, our employer, my son and I, we worked together, and our employer, when we told him that the funeral was on Thursday, he asked if we were coming to work for the 2 days before the funeral. And we both wound up leaving that employer very soon afterwards. And I think that, again, anybody that hears that story is going to go, you really required an employee to come to work, within 24 hours after his mother passed away. So what's your thoughts on that? I know I threw a lot at you, and I'll shut up now and let you finally answer that question.
I would say this is not a legal term, but I would say that action by your former employer is kind of a dick move. So I would not encourage an employer to have that kind of policy. If an employee wants to come to work, sometimes because maybe they just need the distraction, that's fine. But allowing employees to take the time to bereave the loss of loved ones is one way to help employees with their mental health issues. And if it turns out that an employee does have some depression or other issues, mental health issues that would require additional time off, that something, again, will be dealt with the documentation from the employee and going through the interactive process, or perhaps through an application for family and medical leave. So, yeah, that's absolutely, bereavement and the loss of a loved one can certainly either trigger or perhaps enhance a mental health issue that's already there. And so it is healthy to let employees take time off to bereave and grieve for the lost loved ones. And if they need extra time, to be flexible about it. This is one of these areas, unfortunately, where I think employers have cut back on some bereavement leave because you have those few employees that unfortunately abuse it. And it's one of those situations where a few people make it miserable for the rest of us because they have abused the policy. And that's unfortunate. And that happens with other policies as well. And you hate to see that happen. And you really don't want to have the employer crack down on everybody due to the bad actions of a few.
Yeah, I agree. And I think situations like that are oftentimes ripe for abuse, but you don't want to swing the pendulum the other way. And one of the topics that is coming up very soon is we're going to talk about the type of employee who is potentially going to sue you. And I think a lot of times, again, there may be situations that come up are not directly related to the lawsuit, but if you have a situation where an employee feels aggrieved in one area, which is, let's say, with a bereavement policy, that they're going to begin to start looking for a reason to sue the employer, or at least make things difficult for the employer on the way out the door. So these are all things that may not be directly related, but they could be indirectly related. And I'm looking forward to that particular topic. I think it's going to be a lot of fun. Well, we talked about one personal story I had in terms of, my mom and our mom, that when she passed away and how the employer handled it. Now, here's another scenario that I'll throw at you. And I know we've talked about this one as well before. And I was a special education teacher. And this will be related to the FMLA. And I think most employers know by now that mental health is covered by the FMLA. It's not something where you have to leave for just a sick mom or a sick dad or a sick kid. It could be yourself that is dealing with issues, especially if it's a mental health issue. And I worked with a teacher. She was going through a divorce and just, I guess, having a rough time of it. And she had, I guess it would be called an intermittent FMLA claim. So she would leave, she basically was given carte blanche for to call in on days that she was dealing with excess anxiety. And I knew this because it was something that she had shared with multiple employees. So I don't want to give the impression that the employer gave us this information. They didn't. They were actually very cautious and very respectful of her mental health condition, to their credit. And employers listening out there, you got to be careful when it comes to this stuff. If somebody's calling in sick, you can't say what's going on. If the employee, though, decides that they want to tell everybody, then, hey, that's their business. Anyhow, it got to the point where with her calling in sick all the time that everybody else had to pick up the slack. And it really had a negative impact on just the day-to-day operations of that particular school. Now, she wound up eventually getting terminated because she had posted some risque photos on social media sites, which I don't think we need to do an episode on not posting risque photos on social media if you are a special education teacher that has many of your students following your feed.
Well, apparently maybe we do, because not everybody understands that you're not supposed to do that.
Yeah, it was... I mean, I can only describe one in a way that's semi-professional, because this is a professional podcast. I mean, the only thing she was wearing was underwear. She had her hands down her underwear, and she had all these pictures, kind of covering certain parts of her body so that she would get past the standards on Facebook. But that was eventually the final straw. But I remember having a conversation with somebody that had to deal with that particular situation, and they said that it was tricky because you had these two things going on. You have the FMLA claim, but then somebody does this just egregious thing on the side that they eventually wind up being terminated for. So I don't know what your thoughts are now. Even as I discuss this, I think, well, maybe that crazy, and I hate to use the term crazy because we are talking about mental health, and I don't want people to think that I'm characterizing people with mental health issues as crazy per se, but I feel like her actions were crazy to post those photos on the internet. But I almost wonder if she could have turned around and said, well, that's a function of my mental health issues. Either way, the employer wound up getting her out, and I don't know what happened there. But I wonder what your thoughts are in terms of, that intermittent leave and how it impacts other employees, because, again, it caused some problems in the workplace. And then eventually it spiraled into this whole situation where the teacher did something that was just ridiculous.
Well, normally the intermittent leave, it's something that is available under the FMLA, which is that employees can take less than a full day off under FMLA. But normally you want it to be something that is fairly predictable, because like you said, when you have an employee and you don't know whether they're going to show up from day to day, that puts a lot of burden on the other employees that are at work, because they never know whether they're going to have to pick up the load for the person who's not coming in. So that is a concern. And that's why you really want to try to make the intermittent leave as predictable as possible, so that the employer can then make any kind of allocations of the work in advance and make sure that the other employees are not overburdened. With regard to, well, first of all, I'm going to say, Tom, you shouldn't use the word crazy. Mental health is one of these issues because it's covered by the ADA. You cannot harass someone on the basis of mental health issues, which means that if someone is aware that someone in the workplace is maybe struggling with some mental health issues, you don't want employees talking about them as crazy or nuts or anything like that. That could be considered some kind of harassment, or even some kind of discrimination if it's got a negative connotation, which it certainly does. And again, mental health issues have a lot of stigma. So if an employee comes forward and reveals that they have a mental health issue, you want to make sure that the other employees and the supervisors and the managers respect that and show respect for that. And not, if they have personal views about mental health, and there's people out there that think, don't take antidepressants or just tough it out, they can keep those views to themselves. They don't need to be talking about it in the workplace, especially if there's someone around who is dealing with that particular issue.
Absolutely. And I think that's a great ending point for what has been a very informative. It's a topic that we certainly can revisit at a later date, and one that's timely. I know that the mental health issues, like you said, they're very complex. And I'll give you a minute, as I always do at the end of every episode, for a couple of takeaways. I mean, the one that definitely comes to mind, the top of mind right now, is that you always got to be very sensitive to these types of issues, be aware of them. And some of them are just so complicated that you just have to be able to deal with each one of them with an open mind and on a case-by-case basis. What other takeaways do you have from this particular episode, Sister Kathleen?
I would say another takeaway would be do what you can to try to assist your employees who have mental health issues, and try to encourage them to get the help they need and not stigmatize mental health issues. Also, keep in mind that these protections can also apply to an employee who is perhaps caring for a relative, a spouse, a child with mental health issues as well.
All right. Well, very good. Well, contact information. How can people get a hold of you if they have any other questions with this particular topic, or any topic, or trainings, or any of those great things that your law firm offers?
Or if you just want to tell us what a great podcast that is, you can shoot me an email at kjj@wimlaw.com.
Awesome. And this has been a great time doing these podcasts. So next week, again, our topic, we'll kind of tease it a little bit, is what was the topic we're discussing for next week?
Well, we're going to profile the kind of people that are most likely to become a plaintiff.
See, now this felt like one of those Batman shows that we grew up with, where you have like the ending and then you got the little cliffhanger. It's like, stay tuned next week for the employee that is most likely to sue you. So that's going to be an exciting one. As always, thank you very much. We did hit officially the 200 download mark for the podcast, which is a milestone. So we appreciate everybody out there that helped us get there. Please start sharing. If you would write a review, we'd appreciate it. A kind word. And of course, and if you have a topic that you'd like us to discuss, we'd be happy to do that as well. So for myself and our resident expert, Kathleen Jennings, we'll see you next week. Same bat time. Same bat channel. All right. Again, thanks for listening to the Cover Your Assets podcast. We'll see you next week.